Please be seated. The sitting is resumed. For reasons made known to me, Judge Donahue is not able to be with us for the remainder of today's hearing. I will now give the floor to Dr. Ben Juratovich. You have the floor, sir.
Mr. President, Madam Vice President, members of the Court, I have the honour to address you on events occurring after the Chilean people restored democracy to their country in 1990, now almost 3 decades ago. That restoration ended Chile's international isolation under General Pinochet. It provided a new democratic context for the relations between Chile and Bolivia. In that new context, both states resolved not to dwell on their history, but instead to concentrate on new practical approaches to improving their relations for the future. The end of the previous historical chapter was embodied in the June 1987 statement of Chile, with which Professor Pinto ended just before the break. Chile indicated that it was rejecting a transfer of sovereignty over territory so as not to give rise to false expectations of the Bolivian government and people. Bolivia cannot now reasonably say, following that statement, that there was continuity or consistency in the interactions of the two states on the topic of transfer of sovereignty over coastal territory. The Chiranya chapter was closed in 1978, and it remained closed. Bolivia had this same understanding as recently as filing its memorial. Addressing Chile's June 1987 statement, Bolivia submitted that the rejection of the Bolivian proposals did not rely on Chile's side on the specific terms of Bolivia's proposals, which could have been the subject of negotiation and reciprocal concessions. Chile's refusal was based on a point of principle. It refused to engage in any negotiation aimed at the establishment of a sovereign access to the sea for Bolivia. According to Chile, negotiations between the two states could only be considered provided that they would not lead to any territorial cession, which is to say, on the condition that they would not involve any sovereign access to the sea. Here, Bolivia made clear what it meant by sovereign access to the sea: territorial cession. And Bolivia acknowledged that in 1987, Chile made clear that there would be no negotiation on that topic. That is the background against which the most recent set of interactions began after 1990. The last 3 decades are important to an evaluation of Bolivia's case. To succeed, Bolivia must establish not only that an obligation to negotiate sovereign access came into existence, but also that it has endured all the way up to the present moment in time. Hence Bolivia's new concentration on the theme of continuity. If Bolivia and Chile were today subject to an obligation to negotiate sovereign access, then in these 3 most recent decades, there would have been documents created by the 2 states recording the existence of such an obligation. And there would have been conduct by both states proceeding on the basis that they were subject to that obligation. Members of the court, there is neither. Following the restoration of democracy in Chile, through until 2011, Bolivia did not claim that Chile was under a legal obligation to negotiate sovereign access to the Pacific Ocean. Bolivia has said the contrary before you, but has not actually identified any evidence of such a claim being made. When in 2011, Bolivia did claim that there was such an obligation, it was in a letter to the court in the context of the maritime boundary dispute between Peru and Chile. After, I emphasise, after Bolivia's president had announced that it would commence a case against Chile. Even then, Bolivia did not, in any communication to Chile, claim that there was an obligation to negotiate sovereign access, nor that Chile had breached any such obligation. There were also no actual negotiations in this period on transfer of sovereignty over territory. And precisely for that reason, Bolivia argued in its memorial that from 1987 onwards, Chile was in continuous breach of an obligation to negotiate said to have arisen prior to 1987. Now, this could not plausibly be maintained because from the restoration of democracy through to 2011, Bolivia never once alleged such a breach. Confronted with that difficulty, Bolivia rather dramatically changed its case in its reply to argue that the very same conduct that in its memorial it regarded as a breach of an obligation to negotiate, instead, Bolivia then said, created an obligation to negotiate enduring throughout the very same decades. This was part of a broader new case developed further this week. That new case is that from prior to 1895 through until 2011, Chile was subject to and reiterated one continuous and consistent obligation, which Chile breached in 2011. This new focus on continuity up to 2011 is obviously inconsistent with Bolivia's case in its memorial that the obligation arose in 1895, from which point there was a progressive degradation of the obligation from 1895 through to 1987, followed by a continuous breach from 1987 onwards. On Monday and Tuesday, most of Bolivia's counsel stayed true to Bolivia's new case that the alleged breach came only in 2011. But they left Professor Forteau with the task of trying to explain in the last speech what had happened between 1987 and 2011. He reverted to the position that Chile breached the alleged obligation in 1987. The court would doubtless be assisted in its assessment of Bolivia's case if on Monday Bolivia's counsel could present just one definitive and clear position on whether, in Bolivia's view, from 1987 to 2011, Chile was or was not in breach of the obligation that Bolivia asserts. Of course, whichever legal argument Bolivia ultimately settles on will not affect what actually happened. And it is to that I now turn. To seek to show that something since 1987 created, or at least confirmed, a continuous obligation to negotiate sovereign access to the Pacific, Bolivia relies principally on two documents, the Algarve Declaration of 2000 and the 13-point agenda of 2006. The Algarve Declaration is the rather grand title that has been attributed to identical press releases of each government concerning a meeting of the two foreign ministers in Algarve, Portugal in February 2000. The full text is at tab 78 of your folders. And the central paragraph will be on the screen. It just says that the foreign ministers resolved to prepare a work agenda which will be formalised in the subsequent stages of the dialogue that incorporates, without any exclusion, the essential issues of the bilateral relationship in the spirit of contributing to the establishment of a climate of trust that must preside over this dialogue. This you will recognise as classical diplomatic language that manifests no intention to create any legal obligation. There is no mention of sovereign access to the sea. It refers to an agenda without any exclusion, indicating that the subject matter either state could raise was not limited, but it was plainly not the creation or confirmation of any legal obligation to negotiate concerning any particular subject matter. There is no sign that the two states considered themselves to be already under any continuing obligation to negotiate enduring from an earlier time. Two states without diplomatic relations were seeking to hold a dialogue to improve the relations between them, and they announced that in press releases. The second event from this period upon which Bolivia has seized is the establishment of the 13-point agenda. This was also announced in a press release, this time issued jointly by both governments. It is at tab 81 of your folders and also on your screens. It refers to bilateral meetings held between the Vice Ministers of Foreign Affairs of the two states and adds, as a result of these meetings, both delegations agreed to move forward with the discussion of issues of mutual interest for the two countries, within the framework of a broad agenda without exclusions, supported by effective measures of mutual trust. It continues, in this context, they agreed that the said agenda comprises all issues relevant to the bilateral relationship, highlighting, among others, border integration, free transit, physical integration, the maritime issue, economic complementation, Salala, and water resources. This was overtly diplomatic in character. It used very broad language, which obviously did not manifest any intention to create or acknowledge any legal obligation. It did not refer to sovereign access to the sea, a point on which Bolivia's request for relief depends and a matter to which I will return. As with the Algarve Declaration, it did not suggest that either state considered itself to be under any continuing obligation that arose earlier. Although Bolivia now says that the 13-point agenda created and confirmed a legal obligation, before the Organization of American States in 2010, Bolivia's foreign minister described it as an expression of the political will of both countries. That was entirely accurate. Consistently with the broad terminology used in these documents, in these recent decades, the interactions that did occur focused on new practical ideas, not on 19th century history and not on a transfer of sovereignty over territory. Bolivia's foreign minister thus announced before the General Assembly of the United Nations in 1998 that if we want to find new, different solutions in keeping with the times, we can no longer remain mired in the juridical, diplomatic, and military logic of the past. One way in which the two states together pursued that goal and pursued the 13-point agenda was through the political consultation mechanism. Following each of its meetings, minutes agreed by both states were produced. The agreed minutes from 2007 referred to taking into account the conditions prevailing in Chile and Bolivia, and recorded a common desire to keep the bilateral dialogue constructive and focus on criteria that were shared. This was described in the agreed minutes from 2008 as a realistic and future-oriented approach. In 2009 and 2010, the agreed minutes recorded the mutual desire to find initiatives that were constructive and realistic and practical, and feasible and useful. All of these extracts from the minutes were agreed under the agenda item designated as the maritime issue. In its reformulated case on continuity, Bolivia has sought to rewrite that broad diplomatic expression to become sovereign access. Professor Forteau accused Chile of playing games with words, for insisting that maritime issue and sovereign access did not mean the same thing, as though these two states, with their history, would have drawn no distinction between sovereign access and maritime issue. But the words themselves and the agreed minutes of what was discussed under the agenda item for which they were the caption demonstrate how revisionist that is. Professor Ramiro Bretons said that the two states ont délibérément adopté une terminologie ouverte parce qu'ils ont appris par expérience qu'une terminologie plus précise peut alimenter une pression néfaste dans la négociation de l'accès souverain en devenant le centre de l'attention médiatique et des attentes qui produisent des résultats immédiats, tout en divisant l'opinion publique. And yet, Bolivia is requesting the principal judicial organ of the United Nations to make an order in the terms that Bolivia acknowledges that the parties themselves studiously avoided. Maritime issue was not code for sovereign access. It was not just the words that were controversial, it was the very idea. Maritime issue was an expression that may have allowed Bolivia to say for its own internal political purposes that it was maintaining its aspiration, but it neither required nor actually involved the negotiation of sovereign access as now claimed by Bolivia. Professor Ramiro Bretons accused Chile of hyper-formalism. It is not, with respect, formalistic to be concerned before the court with what words representatives of states actually chose to use, and with the meaning of those words. These discussions were focused on pursuing practical initiatives that might be politically acceptable in both states. In the preliminary objections phase, Bolivia was acutely conscious of that and indeed deployed it to its advantage. As part of its argument that the court should take jurisdiction, Bolivia emphasised that the outcome of any negotiation between Bolivia and Chile that it asked the court to order might be, I quote, a special zone or some other practical solution. End quote, rather than a transfer of sovereignty over territory. Having passed the jurisdictional hurdle, those expressions and the ideas they represent appear to have disappeared from the Bolivian lexicon. But of course, the evidence remains the same. And the evidence is that what was being discussed were potential practical initiatives. In 2008, consistently with the agreed minutes you saw a moment ago, the Chilean Foreign Minister stated before the General Assembly of the Organization of American States that the maritime issue was a question of exploring constructively and creatively formulas that make possible a better access to the Pacific Ocean for Bolivia, Chile reserving its legal and political positions on the matter. Therefore, the goal of this process cannot be a sovereign outlet to the sea, because if that were the case, my country would not have agreed to include this item in the agenda. In that 2008 statement, Chile made clear its position, and if Bolivia had not agreed with it, if that had not been a shared understanding of the diplomatic process underway, Bolivia doubtless would have said so before the General Assembly of the OAS, before which it has not demonstrated any timidity, or at least in a communication to Chile. But Bolivia was silent. It was silent because that was a shared understanding and was precisely what was happening. And not just in 2008. 12 years earlier, in 1996, the Chilean foreign minister had stated that Chile is willing to discuss new modalities of access to the sea for Bolivia, provided that imaginative formulas are used that do not mean cession of sovereignty by Chile. In 1997, the Chilean foreign minister stated that Chile has granted Bolivia the largest and most extensive facilities for access to the sea. Chile is willing to continue down the same path, but cannot, under any circumstances, include the cession of territorial sovereignty. Consistently with this evidence, Bolivia's memorial made these representations to the court. At paragraph 469, concerning a statement by Chile in 1991 about its territorial integrity, this signalled that any negotiation related to the grant of a sovereign access to the sea for Bolivia was excluded. In 2004 and 2005, Chile said that it was ready to talk to Bolivia, but only on condition that the negotiations would not deal with the issue of the sovereign access to the sea. In 2008, as well as in 2009 and 2010, Chile again limited the scope of negotiations by excluding any possible consideration of a sovereign access to the sea. Bolivia noted that Chile's statement in 2008 incorporated the substance of Chile's June 1987 statement, with which Professor Pinto ended and I began. So continuity, but not of the kind that Bolivia is now asserting. This all comes from Bolivia's own memorial, which explained accurately that both states understood throughout these decades that Chile was not willing to negotiate a transfer of sovereignty over territory. Blithely pretending that its memorial did not say these accurate things, Bolivia's reformulated case in its reply, and earlier this week, invokes estoppel and asserts that there was a consistent representation maintained by Chile concerning the negotiation of sovereign access that persisted consistently and continuously from the 19th century up to 2011. Bolivia has still not been clear about the precise content of the representation it alleges. But whatever it might be, Bolivia's new case on estoppel is flatly contradicted by the statements you have just seen. There was no clear and unequivocal representation by Chile persisting up to 2011 on which Bolivia could rely. And Chile did not, to use the court's words in Cameroon, Nigeria, consistently make it fully clear that it was willing to negotiate sovereign access or that it considered itself legally obliged to do so. The evidence and the extracts from Bolivia's memorial accurately describing that evidence indicate that Chile stated that it would not negotiate sovereign access. If at some point in history prior to 1987 there had been a representation by Chile that might, theoretically at least, in due course have led to an estoppel, which of course there was not, then any such representation would have been countermanded by the many statements Chile later made. Even if a representation can be established, a claim of estoppel must fail if that representation is later countermanded before it is relied on. And as Dr. Parlett demonstrated yesterday, there was no such earlier reliance. Nor was the crucial element of reliance satisfied in this later period. On the contrary, Bolivia understood that Chile would not negotiate sovereign access to the Pacific because Chile kept saying so. And Bolivia proceeded on that basis and engaged with Chile over decades on a range of practical initiatives to improve Bolivia's access to the Pacific Ocean. As well as its significance for Bolivia's estoppel case, this period of time also further demonstrates the fallacy of Bolivia's case that there was some kind of tacit agreement, starting much earlier in history and stretching through these decades to the present. An agreement that is tacit is still an agreement the existence of which must be proved. In the press releases constituting the Algarve Declaration and the 13-point agenda, in the agreed minutes under the political consultation mechanism, and in all the other interactions between the two states since 1990, neither state made any explicit or implicit reference to any pre-existing agreement, tacit or otherwise, to negotiate sovereign access. That is because there was not such an agreement, and neither state thought that there was. I turn now to Bolivia's change in position in 2011, following which it abandoned the constructive bilateral engagement on practical initiatives and seized the court in pursuit of a transfer of sovereignty over territory. Bolivia claims that it was forced to resort to the court because of what it now describes as an abrupt and arbitrary change of position by Chile in 2011. In Bolivia's reply, and for most of its counsel this week, that alleged change of position by Chile in 2011 is the basis of Bolivia's case on breach of the obligation it asserts. As Chile's agent indicated yesterday, What actually changed in 2011 was that Bolivia decided to act on the international plane in compliance with the requirements imposed on its executive government by the Bolivian Constitution of 2009. And members of the court, I propose to take you to the relevant aspects of Bolivia's constitution and statements made about it as matters of fact before turning to the conclusions that Chile asks the court to draw concerning Bolivia's case. Article 267 proclaims Bolivia's unwaivable and imprescriptible right over the territory giving access to the Pacific Ocean and its maritime space. It declares that the effective solution of the maritime dispute requires the full exercise of sovereignty over the territory giving access to the Pacific Ocean. One of the Constitution's transitional provisions required the executive to denounce and, if necessary, renegotiate those international treaties that are contrary to the Constitution. The same provision stated that the executive must do so within 4 years. That meant taking the constitutionally required action by December 2013. Before the OAS in 2012, the Bolivian Foreign Minister, I quote, demanded the government of the Republic of Chile to renegotiate the 1904 treaty. End of quote. He said that he made the specific proposal of renegotiation under the framework of our political constitution. The Bolivian Senate then specified in February 2013 that the executive could fulfill its constitutional duty not only by renegotiating treaties, but also by challenging such treaties before international tribunals. Just 2 days later, the Bolivian Vice President announced that the political constitution of the state obviously provides for a period up to year-end to adapt all treaties signed by Bolivia with other governments on any subject matter to adapt them to the political constitution of the state. And most certainly, this will be done with the 1904 treaty. Just 2 months after that, Bolivia filed its application with the court, and the documents from the President of Bolivia appointing Bolivia's agent, and just 2 months ago, its co-agent, begin with Article 267 of Bolivia's constitution. As proclaimed in that article, the solution to what Bolivia calls, in its internal law, the maritime dispute, requires the full exercise of sovereignty by Bolivia over coastal territory. That is a permanent and unwaivable objective of Bolivia. This constitutional imperative matters for the case before the court for 3 related reasons. The first is that Bolivia came to the court not to seek any recommencement of recent dialogue, but to ask the court to impose a change in the subject matter of that dialogue. The second is that it prompts scrutiny of Bolivia's emphasis on Chile's statements in 2011. Bolivia claims that Chile repudiated the alleged obligation in June and September 2011. Prior to that, on 17 February 2011, Bolivia's president said this: "I will wait until 23 March for a concrete proposal that may act as a basis for a discussion." The court will doubtless be reminded of Professor Lowe's submission that Bolivia does not argue that it can sit back passively and call for Chile to make proposals. Bolivia set a time limit of 5 weeks for a proposal from Chile. That 5 weeks brought Bolivia to its annual Day of the Sea, 23 March, on which in 2011 the President announced in a public address that Bolivia's maritime claim would be taken to court. That decision was announced months before the statements by Chile on which Bolivia now relies to allege a repudiation of the asserted obligation. In Chile's June 2011 statement, the minister said that Chile would not cede territory, which was nothing new, and he also said that the dialogue should focus on useful solutions for the Bolivian people, feasible, concrete, and mutually satisfactory solutions, which was also nothing new. In Chile's September 2011 statement, on which Bolivia also relies for its repudiation allegation, Chile's minister stated that our country has been and always will be willing to engage in dialogue with Bolivia on the basis of full respect for the treaties and international law. And he referred to that dialogue involving concrete, feasible, and useful solutions for both countries. Chile had been stating for many years prior to 2011 that it would not negotiate a transfer of sovereignty over territory. Bolivia was negotiating practical initiatives with Chile on that basis. But in 2011, Bolivia's position changed, which caused Bolivia, motivated by its constitution, to seek a transfer of sovereignty over territory and abandon the constructive dialogue in which the two states had been consensually engaged. The third point is the futility of negotiations on sovereign access. Since Bolivia now cannot, under its constitution, accept anything less than transfer of sovereignty over territory. And its president has publicly so declared. Whereas Chile has for many years made clear that it will not transfer sovereignty over its undisputed territory, and this remains and will remain the case. Members of the court, the question before you is whether Chile is today under an obligation to negotiate sovereign access to the Pacific Ocean for Bolivia. These recent decades demonstrate that it is not. There was no continuity between any previous chapter in history and this modern consensual pursuit of practical initiatives in a democratic context. No obligation lingered on from the past, and none was created in this period. I thank the court for its attention, and I invite you, Mr. President, to call on Professor Coe.
I thank you. I will now invite Professor Harold Coe to take the floor. You have the floor.
Mr. President, members of the court, it's my honor to appear before you on behalf of Chile to conclude our opening round presentations. You've now heard both sides of this case, which in the end is quite straightforward. Chile has never manifested any intention to be bound by international law to negotiate about whether Bolivia might be granted sovereignty over land located on Chile's own seacoast. Bolivia has failed to establish that any individual historical episode created such an obligation by express or tacit agreement, unilateral declaration, or other representation. Nor has Bolivia established that any continuity among disparate historical episodes created such a legal obligation. Even assuming arguendo that some obligation ever existed, Bolivia has never shown that that obligation was ever breached or not fully discharged. Thus, Bolivia has entirely failed to establish any of the 3 points it must prove to prevail: that Chile ever undertook a binding obligation to negotiate, ever breached such an obligation, or that such an obligation still exists today. Bolivia tries to dismiss Chile's rigorous legal analysis as a formalistic flood of details. It offers instead a confused and shifting case that finds no basis in the text of the documents on which it relies, the structure of the bilateral relationship, or the historical record, and rests ultimately on a theory unmoored in law that cannot be squared with the settled practice of international diplomacy. As we have shown, Chile's consistent, unchanging position is firmly supported by these same considerations. As Sir Daniel recounted, Bolivia's case has now shifted 4 times. Bolivia's memorial claimed without basis that Bolivia had a right of sovereign access to the Pacific. At preliminary objections, Bolivia retreated to its second theory, that the court should require Chile to negotiate in good faith about some kind of practical solution. Bolivia's reply thirdly claimed an unwritten 19th century historical bargain, whereby Bolivia somehow agreed to exchange its coastal territory under the 1904 peace treaty for an obligation to negotiate to gain sovereignty over other Pacific coast territory. And as we heard earlier this week, Bolivia now argues for a fourth, no evidence theory of liability. The court needs no evidence of any conduct by the parties to find a binding obligation to negotiate, because that obligation exists as a matter of general international law, Article 2.3 of the UN Charter and the OAS Charter. This free-floating, evidence-free international law duty to negotiate would apparently force Chile year after year to keep returning to the negotiating table, even when Bolivia has broken off diplomatic relations until Bolivia finally gets what it wants. Bolivia would have it both ways. Bolivia first claimed, as you heard from Mr. Geradowicz, that it was Chile's inconsistency from 1895 to 1978, and again in 1987, that breached its alleged obligation. Its reply then claimed that the very same facts constituted a continuous and consistent course of conduct by Chile over time. But whether Chile was too inconsistent or too consistent in its conduct, either way, Bolivia calls it liable. In fact, Bolivia's case now seems to be that almost everything Chile has done or said for more than a century creates a binding legal obligation. Almost nothing Chile could say or do could ever discharge or terminate that obligation. Bolivia's constantly shifting case vividly shows that it cannot identify any real legal basis for either Chile's alleged obligation to negotiate or any claimed breach of that obligation. Even while Bolivia has vacillated from pleading to pleading, Chile has remained consistent regarding both the law and the facts. Chile has consistently called for a plain reading of the documents, accurate appreciation of the bilateral diplomatic history, and faithful adherence to an objective legal test for the creation of any international obligation. The facts show that over the last century, these two neighbors have engaged in diplomacy, nothing more. Chile has listened to Bolivia and at times discussed improving Bolivia's access to the sea, but Chile has never, through written word or unwritten acts, undertaken any legal obligation to negotiate a grant to Bolivia of sovereign access to the Pacific. When Chile did negotiate with Bolivia about its aspiration for sovereign access, as during the Charaña period, those negotiations failed. And Chile never agreed to be legally bound to continue those or other negotiations in the future. Turning to text, earlier this week, Bolivia's council led us on a game of intellectual hopscotch through many historical eras, mischaracterizing many documents from many episodes without ever discussing carefully the text of any of them. Each time Bolivia referred to a historical episode, it tried to deflect the court's attention away from the text of the very documents on which it relies. To give these documents legal significance, Bolivia retrospectively recharacterized the political atmosphere surrounding each. But as my colleagues have shown through a close, honest reading of the text, Chile never, in any of those documents, expressed any objective intent to be legally bound to negotiate. Unlike Bolivia, Chile has anchored its case in the actual text of the many legal documents cited. As Sir Daniel has shown, the bedrock 1904 peace treaty between the two countries made absolutely no mention of any collateral bargain to negotiate to transfer territory to Bolivia. As Dr. Parlett has shown, the documents in the next quarter century that Bolivia claims created or confirmed the legal obligation, in fact, make clear that no such obligation could exist. As quoted, the 1920 minutes explicitly stated that they did, quote, not contain provisions that create rights or obligations for the states, close quote. As Mr. Wordsworth has shown, the 1950 notes were not a treaty because they contained materially different expressions of what each state thought would be politically acceptable and appropriate compensation at that time. And the 1975 Charaña Declaration simply recorded a diplomatic truism. The two states, quote, resolved to continue the dialogue at various levels to seek formulas for solving the vital matters that both countries face. Language that clearly does not and could not manifest any intention to be legally bound. As Professor Pinto has shown, none of the OAS General Assembly resolutions between 1979 and 89, which Bolivia cites, even mentions an obligation to negotiate. All were framed as general political recommendations, nor did anything Chile ever said or did in connection with these non-binding resolutions create any legal obligation. And as you just heard from Dr. Juratovic, after democracy was restored in Chile, the parties never negotiated on the issue of sovereign access, including in the 2000 Algarve Declaration and the 2006 13-point agenda. At most, these documents constituted political frameworks to guide the parties' future interactions, saying absolutely nothing about the transfer of sovereignty over territory. Mr. President, members of the court, as you well know, in high-stakes diplomacy and international law, words matter. Words especially matter when sovereign territory is at issue. When a nation claims that documents create binding obligations, it must clearly point to the words in those documents that created those binding obligations. As Chile has demonstrated through its comprehensive chronological review, Bolivia has not pointed to a single document, not even a single word, that fairly read creates any basis for the alleged obligation to negotiate. The structure and nature of the cooperative bilateral relationship between the two parties confirm what we can conclude from text, that no legal obligation was created. Bolivia suggests without basis that Chile has been a bad neighbor. As our agent, Professor Grossman, explained, history shows the opposite. A central feature of the state's bilateral engagement has always been Chile's openness to Bolivia's concerns and its conscientious engagement on issues of mutual concern. Over the last century, the bilateral relationship has been characterized by cooperation in a multitude of areas: political, economic, social, scientific, cultural, educational, transportation, immigration, and technical fields. These overlapping zones of cooperation were clearly set out in the agenda of 13 points that framed the parties' engagement in the years after 1990, following Chile's restoration of democracy. Now, at times, these bilateral cooperative arrangements address Bolivia's access to the sea. Mr. President, members of the court, Bolivia has access to the sea. It has had access for more than a century. Contrary to Bolivia's rhetoric, there is no wall. Under the governing 1904 peace treaty, Bolivia has enjoyed for more than a century the freest right of commercial transit across Chilean territory and through Chilean ports at very substantial annual financial cost, which Chile gladly bears to support close neighborly relations. Chile is an open society, one of the most open in the hemisphere. Its abiding openness to engaging with Bolivia as a good neighbor on such matters of mutual concern reflects the cooperative dialogue that has characterized that relationship. Chile recognizes the importance of Latin American integration and solidarity based on bilateral and regional cooperation under international law. Yet, as Bolivia did in 1962 and again in 1978, Bolivia met Chile's collaborative spirit with dissension. It severed diplomatic relations when it became dissatisfied with the relationship. On the one hand, Bolivia has refused to maintain regular and continuous diplomatic relations for 53 of the last 50 years. On the other hand, it insists that Chile is legally bound by a continuous century-old obligation to negotiate, in which every act or statement by Chile that mentions anything related to the sea reaffirms its claimed historical bargain or creates unwritten legal obligations. 7 years ago, Bolivia abruptly shifted to its current posture of litigation, provoked, as you just heard, not by any action of Chile, but by Bolivia's new constitutional imperative to, quote, denounce, renegotiate, or litigate concerning any treaties that limited its access to the Pacific. In the end, that constitutional imperative, not any provocation by Chile, drove Bolivia to this court. So there is a simple answer to the question Bolivia has asked several times. Why are we here and not at the negotiating table? The answer, because Bolivia brought us here, and because of its own constitutional imperatives, not because of anything Chile ever did or said. As my colleagues have thoroughly explained, history, fairly read, also fully supports Chile's case. Bolivia's misleading image of a blood-soaked history is fully rebutted in Chile's counter-memorial. As Sir Daniel explained, these proceedings are not a trial of dueling visions of 19th century history. This court well understands the difference between evaluating political claims and adjudicating legal claims of binding obligation. What is clear is that to circumvent your jurisdictional ruling, in this very case, Bolivia did not challenge the 1904 peace treaty head-on. It instead tried to enforce its invisible twin, the so-called historical bargain that runs through 6 quite different episodes, which arise decades apart, each within its own distinctive political and diplomatic context. Bolivia uses this hypothetical bargain as a device to cover up gaps in time that it cannot explain and that undermine the claims of consistency on which its case now depends. But what Bolivia cannot explain is why, if such a significant bargain endured over more than a century, no one ever recorded it. No document ever mentions it. As you heard during the exchanges of the early 1900s, the 1950s, the 1970s, no one ever brought it up. Bolivia would stitch these disparate historical episodes into a continuous course of conduct. But as we have shown, each episode was sui generis. The episodes were fragmented and discontinuous, characterized by long periods of inactivity, repeated breaking of diplomatic relations, and shifting political priorities and preferences. Nor can Bolivia explain the differences within each individual episode, including the ways in which over time each state's respective interests changed what each state was willing to consider as potential compensation. So these are not identical beads, far from it, and there was never any golden thread that tied them together into a single necklace. The only historical bargain that definitively settled all issues of territorial sovereignty between the two states was the peace treaty of 1904. Before commencing their case, Bolivia never claimed either a continuous course of conduct by Chile or an enduring legal obligation to negotiate. To the contrary, Bolivia concedes that there were long historical periods of silence when it never mentioned sovereign access and became distracted by other priorities. Each time Bolivia suggested that Chile might be subject to a legal obligation to negotiate, Chile promptly and strongly rejected that suggestion, and Bolivia never responded. In sum, contrary to Bolivia's portrayal, the continuous conduct most shown by history has been Chile's openness and good neighborliness. That openness has included discussing ways to improve Bolivia's access to the sea, and it has shown Chile's sustained openness to discussing issues of mutual concern. Which brings me to my final point. In the end, Bolivia seeks to create law from politics. Bolivia asked this court to transform Chile's political willingness to talk at various times into an enduring and binding international legal obligation. By so doing, Bolivia claims international law gives Chile a binary choice: either refuse to negotiate or express a willingness to engage and create a legally binding obligation to negotiate. But if those were the only two options, why would any nation ever sit down with another at the negotiating table in the first place? Mr. President, members of the court, you well understand the world is hardly so simple. Between Bolivia's two artificial choices, either walk away or be bound, lies that vast realm we call diplomacy. Within that realm, responsible states can and must engage repeatedly in legally non-binding political and diplomatic exchanges for the purpose of harmonizing and improving their relations and fostering international cooperation. Every diplomat knows that in a serious negotiation, nothing is agreed until everything is agreed. Dialogue does not automatically create obligation. Agreeing to talk is not the same as being bound to talk. But Bolivia's position would mechanically convert every fragment of daily diplomatic discourse into a source of legal obligation. Accepting Bolivia's position would alter states' settled expectations about their freedom to conduct their diplomatic activity and present them with an untenable choice. On the one hand, incurring legal obligations with every act or conversation. On the other, pursuing a counterproductive diplomatic disengagement. Bolivia asserts that, quote, Chile's willingness to enter into formal negotiations with Bolivia on a matter as exceptional and consequential as sovereign access is, quote, exactly why that willingness, quote, expresses a commitment rather than a mere offer to talk. Bolivia has it backwards. It's precisely when the stakes are highest that willingness to talk alone is not enough. If states wish to be bound, they do not leave things vague. They make their intentions clear. Bolivia urges the court to ignore the details, but the careful, qualified language used by Chile in every diplomatic exchange, as you have seen on your screens, makes crystal clear that Chile never intended to be bound under international law. Mr. President, members of the court, the stakes here, as Bolivia has noted, are much larger than the interests of these two parties. Most states have much to discuss with their neighbors. A great many want something from one another. Those issues may be discussed by successive governments in successive episodes over many decades. According to Bolivia, a country's occasional political willingness to meet at the negotiating table creates a transcendent legal obligation that endures beyond any diplomatic engagement and can never be discharged. Now, many states could, by clever pleading, manufacture historical bargains by sewing together snippets of speeches, ministerial statements, diplomatic exchanges entirely divorced from the text and context of documents relied upon and from the broader history and structure of the bilateral relationship. And those states could then come before this court seeking enforcement of such political patchworks against states who, like Chile, sought nothing more in good faith than to be good neighbors and diplomatic partners, honestly open to dialogue. Which brings me to the position of Professor Lowe, who urges you to impose an even broader positive duty to negotiate, quote, to establish a just solution in situations where international relations are currently disfigured by injustice. His unbounded theory of Article 3 suggests that it is the role of this court to resolve complex diplomatic crises. And he would not limit his free-floating obligation to negotiate to legal disputes because, as he says, justice is not limited by justiciability. Surely all of us who care about human rights want strong judicial enforcement. As our agent recalled, Chile not only helped to create, it actively supported the work of all global and regional human rights mechanisms. But respect for the rule of law and the proper role of this court cautions that we be careful what we ask for. Taken seriously, Professor Lowe's theory, which he rests in part on the OAS Charter, would undermine the Pact of Bogota by mandating that every state party keep negotiating, even after concluding hard-won treaties, to reopen settled bargains. More globally, his theory would broadly entangle every ongoing diplomatic dialogue in claims of binding legal obligation. Yesterday, Professor Tuvinen gave several examples of how adapting Bolivia's reasoning would inject legal obligation into several ongoing diplomatic discussions. In every difficult, long-running diplomatic negotiation, Bolivia's theory would empower one side, or both, to use the court to force the other to negotiate until it reached its desired result. And it would force this court to sit on call near every diplomatic table to decide on an urgent basis whether one side or another was in breach of one of the many steps of Professor Lowe's elaborate duty to negotiate. This court concerns itself with legal obligations and so has set a clear and high bar for their creation. It should be particularly high when one party says that the other must surrender sovereign territory secured by a century-old treaty. That high bar is not one Bolivia can meet. This court has never found that simple diplomatic discussion creates a legal obligation unless a state specifically intends to be bound. Frustration about not achieving one's desired result does not and cannot create a legal obligation. Neither Bolivia's intense desire to obtain sovereign access to the sea, nor Chile's willingness to discuss that desire at various moments is enough to evidence or create such a binding and enduring international legal obligation. Mr. President, members of the court, some of Bolivia's counsel invite you to ignore your own past ruling in this case and impose an obligation of result. Others of Bolivia's counsel urge you to find an obligation of conduct, a novel, no evidence theory that would mandate an expansive, positive duty to negotiate. Taken seriously, either theory would apply well beyond the facts of this case and transform many aspects of daily diplomacy into binding law. to accept any of Bolivia's many positions, and there are many, would offend the text, history, structure, and common sense of these two states' bilateral relations. For all of these reasons, Chile respectfully asks this court to refuse Bolivia's invitation. Mr. President, members of the court, that concludes Chile's opening round of presentations. Thank you all very much for your kind attention.
I thank Professor Ko. I would like to remind you that this brings us actually to the end of the first round of oral argument. The court will meet again on Monday, 26 March at 10 a.m. to hear Bolivia's second round of oral argument. At the end of that sitting, Bolivia will present its final submissions. Chile will present its second round of oral argument on Wednesday, 28 March at 10 a.m. At the end of that sitting, Chile will also present its final submissions. It is important to recall that in accordance with Article 60, paragraph 1 of the rules of the court, the oral statements of the second round are to be as succinct as possible. The purpose of the second round of oral argument is to enable each of the parties to reply to the arguments put forward orally by the opposing party. The second round must therefore not be a repetition of the arguments already set forth by the parties, which moreover are not obliged to use all the time allotted to them. The sitting is adjourned. Thank you very much.